We are back with another show. I am your host, Dave, 10-year intellectual property attorney, dealing with everything from patents, trademarks, copyrights, as well as trade secrets. And hey, we have a lot to got to get to and kind of different stories that we will be getting to. It has a lot of different various IP that we're going to talk about from lawsuits. Seems like the 007 has the trademark or the intellectual property of 007. James Bond has a new owner. We'll be getting off into the electric vehicle maker, Nikola, filing bankruptcy, and maybe some opportunity there. We'll be getting off into Whataburger. Typically, restaurants, it seems like, and look, I'm in the great state of Michigan, so we don't have a Whataburger here. I think we have like a Wayback Burger or something, but I don't think Whataburger has made its way up to here, the state of Michigan. But it seems like they, as a restaurant, has been sued for patent infringement, which is different from a restaurant because typically restaurants maybe kind of get sued for trade secret infringement or trademark infringement. So that's going to be a new twist that we're going to talk about. And then Big Boy. Yeah, I'm surprised that these big boy things are still, restaurants are still running. But it seems like two big boy franchises are at odds. And again, that is a different one. If you're like, okay, how can you have two different big boy franchises or two big boy restaurants that own an actual trademark for big boy? They have kind of sued each other. So we'll be getting off into that. So we have a ton to get to today. So I don't want to kind of hold you guys up. Some housekeeping items. Please hit the like button for the actual YouTube, the YouTube algorithm, as well as hit the subscribe button to be a part of the IP community. And a big note, I have came out with I'm coming out with some books here, and I wrote the first one, and I actually filed for copyright with the copyright office on that book. And I made a video of that. It's literally kind of from start to finish, me filing that copyright application. And that's on the YouTube channel, Everything Intellectual Property, but it's for members only. So, and I think it provides some great value. That's why I made it members only aside from like maybe just kind of the free public videos. So you have to be a member to watch it. But I'll tell you what, that's some real value. And I know, hey, we're all creatives out there, whether we have a book or a song or a beat that we're producing, or maybe a choreographed dance, a picture, 2D picture. We all have kind of different creative works that kind of we're coming out with that we probably should protect. And I think this video is going to help you understand the process of what goes into kind of filing for a copyright with the copyright office. Again, I'm taking you through it from start to finish. So go kind of check out that video. Like I said, it's for members only. So we're going to get right into it. Like I said, we have a lot to cover. And unfortunately, I'm not going to be doing this live because I'll be traveling by the time this comes out. I'm actually doing this right before I'm heading to the airport to go to Chicago this weekend. And, when I come back Sunday evening is when this actual kind of video will air. So I'll be in the airport or maybe in a plane by the time that this comes out. Nonetheless, we're going to start with custom fit mouth guards. So let me kind of bring it here. And I'm going to kind of play you a snippet from the interview with the co-founder, Matt. And again, Matt was on Shark Tank. You see the video here down to the left where he did a deal with the guest shark at that point, Ray Sean, who, again, he kind of private equity is a big dog in that space. And he actually is a partial owner of the actual Atlanta Falcons. So Ray Sean is, fortunate enough, got a deal with Ray Sean. And again, from talking to Matt on this interview, please check out that full interview on the channel. It seems like Matt is saying that, hey, man, Ray Sean is a real deal, real cool guy. So kind of shout out to that. I do want to kind of play this pic or this video, a portion of a snippet of the video where kind of Matt is just talking about entrepreneurship. And I'm telling you, some jaw dropping, some information that he's giving. So I want to play it really quickly, and then I'm going to kind of give you my thoughts on it. Let me make sure this thing is at kind of the right speed, because I know sometimes I'll be watching these things at okay, yeah, so I think it's on a normal speed. Let's go.
So I was like, what can I lose? And so like I was living in low income housing. I was like, why might as well just go for it all. And so that was kind of my mindset, once I moved away from, pushing for medical school. It's like, I took out like $60,000 in credit card debt to initially build the manufacturing in my like second bedroom, my apartment.
Really?
And you almost move into it ignorantly.
Yeah.
And then, because any sound individual would not take many of these risks. Why would you go $60,000 in credit card debt and then like have no product? And really, because you don't even have, I was so young. I was 24 when I started, or 26 when I started. And so it's like I had nothing to lose. My thought was, if I went bankrupt, like, what's gonna happen to me? Nothing.
Oh, yeah. I thought he said a lot of things there. Some things that kind of maybe caught my attention on that kind of portion of the interview. Number one, start young. Yeah, he talked about him kind of being in low income housing, and now, yeah, man, this guy on Shark Tank did a deal with Ray Sean. Man, he was kind of showing me like actual interview where he has the LA Rams, a lot of different sports franchises, professional sports franchises from the NFL to the NBA to hockey. Whoever wears mouth guards, they are kind of doing business with him. A lot of those professional teams are doing business with them. So just think, being low income housing to being tens of thousands of dollars. I think he said at one point he had $125,000 on his credit card, and all of a sudden it seems like things are peaking up and they're kind of entering some new markets. And again, they're going to be somebody that he's going to get paid a lot of money one day. I can tell you that. Matt, he's in a good position. He's going to get paid a lot of money one day. But again, just for entrepreneurs who may be watching this, I think it's important to understand, man. Like I said, number one, I think the big thing that he said, get started when you're young. When I was dealing with real estate specifically, and it was easier for me because I got started at 24 years old. So when you get started to something in your 20s, it just makes it a lot easier because you really, a lot of times, don't have nothing to lose at that point. I know when you're older, maybe 40s, 50s, whatever the case may be, you can still get started, but you just have accumulated more stuff, maybe some kids, maybe a house or a spouse, and you just kind of accumulated more things that now you can't be as risky. Whereas when you're young like that, you can be more risky. You can put $100,000+ on your credit card where you're probably not going to do that at 40, 50 years old. Not saying that I recommend you to put all that money as debt on your credit card. Maybe you could have did it a different way. But again, him being young, taking those risks that, as he said, maybe the same person wouldn't take. But again, it had paid off to him. So again, I thought it was a cool video. Shouts out to Matt. Please go check out that video on the YouTube channel, Everything Intellectual Property, the full interview, where again, Matt is dropping some jewels with that. So kudos to Matt. Let's move on to the next one. Nikola. I actually did a lot of these videos, or not videos, but a lot of these stories that we're going to talk about, they're more so quick hits. When I say quick hits, meaning that, hey, I kind of talked about it earlier on the week. I kind of talked about it, and I'm just kind of want to kind of hit it quickly during this show where I'm hitting on a lot of different topics to kind of give you my thoughts. So Nikola, and I actually was at the day after I did this video, I was at a cigar lounge here in the area that I typically go to, and the general manager of the cigar lounge, I was telling them that Nikola, we were talking about IP and the value of IP and how a lot of times when companies go through these bankruptcies or they're facing financial difficulties, they're looking to sell off assets. And we all know about the actual product that they're maybe selling, or like machinery or the vehicles, or again, you may have an account receivables, and it's a number of different assets that a company can have that they want to sell off. However, IP is one of those assets. And I guess we need to look at it, the situation differently. I know a lot of times we look at it as a laughing opportunity when somebody is saying, hey, this company is going through bankruptcy, or this company is going through bankruptcy. We want to laugh and make a joke, ha, 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 out of it. But we really do need to kind of train our minds to think differently about it. Because again, a lot of people are thinking differently about those situations. They're looking at them as opportunities in terms of, okay, let me see if I can call up such and such or go to the auction. I think Dr. Dave Smith, who I interviewed, he talked about that, where it was a wound care company that they were facing some difficulties, and he went to the auction and got the whole IP portfolio for $27,000. Next thing you know, he was able to add to it, kind of build up the company, sell it, probably make hundreds of thousands of dollars, if not millions. And now he's kind of rocking and rolling. So we have to kind of train our mind differently to say, hey, okay, this company is facing a challenge, particularly if it's a company that we like. Let me see if I can kind of turn this into an opportunity to reach out and see if I can buy that IP, whether it's trademarks, whether it's copyrights, whether it's patents, trade secrets, whatever. Let me see if I can buy that, maybe add some value to it, maybe combine it with some other stuff that's going on. Next thing you know, it's you are kind of better off as a result of it. So again, going back to the Churchill story, I said the name of the company, the cigar lounge that I didn't want to say. But anyway, so being at the cigar lounge, talked to the general manager, and he was kind of pissed because he's like, man, yeah, I invested thousands of dollars in Nikola, and it seems like early on they kind of stock shot through the roof, especially when they went public. But it seems like now, man, they've been facing financial hardship for a couple of years. It seems like the founder, maybe a number of years ago, he was sentenced to prison time or jail time, kind of doing some wire fraud and some other bad things. And seems like the C-suite has kind of rotated a number of times, and it seemed like they had a recall. So I'm not saying that the EV market necessarily is in turmoil, but it seems like Nikola did some things that, whether it's CEO having wire fraud or committing wire fraud, plus it seemed like they had a recall on vehicles based on a coolant leak. So they had some things that, when you're talking about a startup company, doesn't help you as it relates to kind of build a customer base. So it seemed like that ultimately got the best of them, unfortunately. However, like I said, we need to look at these opportunities to actually be able to, provide opportunity, or look at it as an opportunity as opposed to just be able to laugh and and make a joke that a company has went bankrupt. Because I would imagine, I think I put it up on the actual story, they have at least 80-something patents that are pending. I would imagine that they have more than that. And some of those patents may be good, some of them may be bad, but I would imagine that the Teslas, the GMs, the different OEMs who deal in that electric vehicle space will be calling Nikola to say, hey man, let's get this IP from you. Let's buy this IP from you. Again, you're getting this stuff either pennies on a dollar or at a steep discount. So hopefully you guys kind of really understand that, because I do want to kind of really harp on that point. Is, man, we have to start looking at these things as more of an opportunity as opposed to just something to kind of laugh at. So let's move on to the next one here. And again, a lot of these are quick hits, just as a weekly recap until we get off into the lawsuit that we're going to talk about. In this case, is a big boy. So this is one with the Crips owner. Now, to be honest with you, man, I'm kind of not a big fan of Tia. I had did a video that she had that was on, I think, Cam Capone News. So shout out to Cam Capone for interviewing her, and she had kind of was talking about the Nipsey Hussle trademark situation, where how she tried to trademark the term "the marathon continues after his death," and the way she tried to explain it was she was trying to prevent them, whoever them is, from going after his estate and essentially trying to take advantage. And I think that's BS. Ultimately, Black Sam had to sue her to get ownership of the mark, of the trademark application, which goes to show you that, hey man, if you were doing it for Black Sam, if you was doing it for the family, you should have been able to just kind of freely hand it over. But it seems like maybe she wanted something to return, and now he had to sue her. And thankfully, he was able to get the mark back. So that kind of soured my kind of taste on Tia and kind of what she stands for. However, again, I'm objective enough to be able to show when somebody's actually giving game. And I thought what she was talking about, the Crips and the Bloods, in this video was pretty spot on. So I'm not going to play the entire video. I'm going to play a snippet, and then I'm kind of going to give you my thoughts, and we'll move on to the next subject. Let's go.
Do it now. You keep it for sale.
Let me see, man. Like I said, a lot of times I watch these on 2X just so I can get through the content. So
keeping, and when it's time for everybody to come to the board, then we do whatever we need to do with it. And that's what I needed to do. I needed to go, because when you're serious about your cripping, you do serious things. You see what I'm saying? And so that was a serious move that I made, and I did it on behalf of the culture, not for myself. And I mean, I have enough business savvy and
definitely have some business savvy,
experience to know when to make a move. And so I did. And not that I'm the leader of it or anything like that, because Crips don't have a leader. You know what I mean?
And this is where it kind of starts for me to kind of, again, man, I'll stop you right there and just kind of give you my thoughts on it. Man, anytime somebody starts to talk about, hey, I'm doing it for the culture with regard to IP, I always look at them like, okay, sure. Just because, again, number one, I'm with her when she says kind of filing trademarks on the Crips and the Bloods, and turning something that was once or probably still is this illegal activity, and them engaging in illegal activities. Say, okay, let's kind of bring it over to the actual legal realm and being able to sell products, Crips and Blood, and leverage, I guess, the name. I'm not sure if it's goodwill attached to the name, but definitely it is a brand and a name nonetheless. Being able to leverage that brand and name to kind of sell product. It seems like she has a book in the background. She has some cola. I'm assuming the red cola is for Bloods and the blue cola is for Crips, and I'm not sure what the stuff to the left of the colas is, but she seems like she's selling product. And I'm all for people protecting the intellectual property, whether it's trademarks, patents, copyrights, and kind of doing something legally. But when you start talking about, hey, I'm not the owner of Crips and the Bloods, and I'm doing this for the culture, and like I said, I'm hesitant, or my eyebrows raised, just because at the end of the day, sure, you're not the owner of the Crips or the Bloods, but you own the trademark because you filed for a trademark right. So when you start to say, hey, we all got to collectively make a decision on how we want to do this, how we want to use the mark, so forth and so on. Yeah, that's not true, because you are the owner of the trademark. Now, if you said, hey, this collective is the owner of the ship, has ownership of the trademark, then the collective really owns the trademarks and they can do with it the way, whatever they need to have done with it. But I'm assuming that on that trademark application, Bloods LLC, Crips LLC, you go kind of dig up the information, you probably are the owner of both of those entities. Maybe you have some co-founders or co-owners or whatever the case may be, but those decisions are not being made with the collective as a whole, as you try to put it. Yeah, us as Crips, us as Bloods have to kind of determine how we're going to use the mark. It's going to be you determining that. And so, I mean, just call it what it is at that point, as opposed to trying to sugarcoat it and say, hey, I don't own the Crips and the Bloods. Well, you own a mark of it. So like I said, I think it's gamesmanship in that point. And like I said, with all the stuff that she already talked about with the Nipsey Hussle stuff, I maybe am not as much of a fan. So that's the Tia information. Let's go to 007. So James Bond, and this is actually funny because I was spot on my analysis of this, whereas it seems like this was actually in the EU, where an Australian billionaire, a real estate property billionaire real estate developer, had petitioned to cancel the mark with the European Union. So Europe, once a mark has not been used for 5 years, you can petition to cancel the mark. Now, this guy most likely is going to lose his petition to cancel the mark. But again, that was my original video on 007 James Bond. And at the end of the video, as we're going through the article, it was saying that, hey, it appears that Eon, which is the company that owns the mark in Europe, or have the rights to it at least in Europe, as well as Amazon, kind of have ownership of the mark. And it seemed like they were at odds. Seems like Amazon was kind of disputing the fact that they were at odds. I'm like, well, it seems like they're not going to do anything with the franchise, with 007 James Bond, until either Amazon owns it or Eon owns it. And like a day or two later, it comes out, this was yesterday, so it came out that Amazon and MGM Studios gains creative control of James Bond franchises from the Broccoli family. So again, the Broccoli family is essentially the company. Eon, I think, is the name of the company. It's owned by the Broccoli family. And it seems like Amazon paid like $2.some billion. So I'm like, hey, if Amazon paid $2 billion for the franchise, you better believe that the franchise is not going anywhere. But it seems like they had some kind of creative, they weren't aligned in the creative, in alignment as it relates to the kind of creative control of things. And I said on the video, hey, two things are going to happen. Either Amazon is going to have to gain creative control, or Eon. But it seems like they're kind of not getting anywhere with both of them in ownership. And like I said, maybe the very next day, Amazon gains control. So yeah, shout out to James Bond. Like I used to play it back in the day where it was like the video games growing up, when you come in a room on a video game and the bad guy's like, Bond is here. And they start like firing at him. And I thought that was cool. But no, other than that, I haven't watched James Bond or participated in a video game or played a video game in a while. So for those of you who, as this billionaire real estate developer in Europe, are big fans of James Bond and want to see it continue to go, it seems like you should be expecting a James Bond flick or your film sometime soon. So, that's pretty much it with that. Let's move on here. So there you go. To Whataburger. Now, as I said at the beginning, Whataburger, I'm going to kind of do it like that. There we go. So again, Whataburger, it seemed like it's a burger joint that was based in San Antonio, Texas. I think they had like just shy of 1,100 franchises, or essentially stores, a lot of them being maybe in the Texas area and more so down south. Like I said, I'm in Michigan. One hasn't made its way up this way, but it seems like it's a decent burger nonetheless if you have 1,100 stores. And they were sued by what I'm calling a patent troll. So a patent troll is somebody who has a patent, because again, unlike trademarks where you have to actually be using a mark, you don't have to do that with patents. You can get a patent and sit on it. And obviously you have to pay maintenance fees, and after 20 years it expires, but you can get a patent and sit on it. And typically what you'll have, what we call a patent trolls in a profession, is somebody who gets a patent, they don't practice the invention, they're not using it at all, they're not necessarily licensing it to anybody, but when they get word that somebody else is using it or kind of doing something with it, then they'll go sue them, and they're essentially looking for a payout. They want a settlement, maybe get $10,000 here, $20,000 here, maybe $50,000 here. Again, this patent infringement or IP infringement in general, it's expensive stuff. So you don't want to have to go through a lawsuit if you don't want to or if it's not necessary. Now, sometimes you'll still do it just to prove a point, but a lot of times, to the extent that you can resolve it amicably, you will do that. And this patent troll, which is out of New York, hold on, let me see something really quick. There we go, man. My computer was dying, and it seemed like my charger my charger wasn't in. So these patent trolls, which in this case, the owner of the patent was out of New York, they have sued. Look at it. If you sue over 100 people, 100 companies in 2 years, you're a patent troll, because that's very unusual for one company to go around just suing people. Now, you have companies that are more quick to sue you, but again, a lot of those companies, most of those companies are actually using a product. And but again, to sue 100 companies in a couple years, for me, that's a patent troll. So it seems like this patent troll has sued Whataburger for patent infringement, which is interesting because typically, like I said, restaurants, they're not selling a product, they're selling a service, which is providing restaurant services. I guess the product could be the burger or whatever the case may be, but it's not a widget in a sense that you typically find when you're dealing with companies like Apple or Microsoft or whatever the case may be. But it seems like something is going on with their systems that they are infringing this patent from this patent troll. So we'll kind of keep an eye out on that and see how things kind of progress. But definitely be on the lookout for patent trolls. And I will always tell you, to the extent that you have IP, to the extent that you have patent, man, just be looking to use it, or whether it's licensing it or kind of using it yourself. Just don't go around. I mean, again, I guess you can do it, and people do it uses it as a business strategy, but just to go around suing people and trying to get a quick settlement or whatever the case may be, I think that's BS in my opinion personally. So let's move on to the big case for today. And we're talking about Big Boy. Now, at one of my old law firms, back when we were going into the office, they had every week they had like different restaurants coming. And they have different restaurants coming and kind of serving food for lunch. And one of those restaurants, I've never been a Big Boy before this. It seems like it's typically like you see them, I see them, and it's like, okay, how are they still in business? Because you typically don't see cars there or none of that. So that I guess is a conversation for another day. But man, I tried Big Boy out. They actually have a Slim Jim that's pretty good. That was like my go-to. So anytime like Big Boy was there, I had to go get some fries in a Slim Jim. Which, if you guys had the Slim Jim, man, it's pretty good. But it seems like in this situation, just to kind of give you guys a recap, we're going to take a look at the lawsuit and read it in detail. But just as a quick recap, what you have here is you have, again, Big Boy, I didn't realize is a more or less a Michigan company. So they're really kind of based out of Michigan. Then you had another company that had a number of restaurants called Big Boy in other states, Kentucky, really in like the southeast region of Kentucky, I think Tennessee, and a lot of different states. Again, we'll see in a lawsuit once we read it here in a second. But what people don't know about trademark law is you can actually have two companies on the same mark that's dealing in the same services. So it seems like in this case, Michigan, the Big Boy restaurant here in Michigan, they had the trademark term Big Boy, and then the Big Boy that was in other territories, like I said, Kentucky, Tennessee, so forth and so on. They had the Big Boy, and they both agreed that, hey, we're both going to get rights to the term, have trademark rights to the term Big Boy, but you got to stay out of my backyard, and I got to stay out of your backyard. And again, USPTO will allow that, but both parties have to agree. Typically, if, for example, if you had a trademark application for the same word that I had the trademark application for, you filed it first. When the examiner at the USPTO picks up my trademark application, he's going to cite your trademark application. However, I can say, hey, I can kind of call you up and say, hey, man, let's do an agreement. And if you agree to it, the USPTO is going to allow both of us use the trademark. It's called concurrent use, where two parties have the same name that's in the same really class, and they both can use it and have trademark rights to it without issue. Again, And if both parties agree to it, the USPTO would allow it. So it seems like in this case, with the Michigan Big Boy franchise and the franchise of Big Boy in other states, they agreed to concurrent use. But it seems like the Big Boy restaurant in other states, kind of maybe at least one location, face some challenge. And I'm giving you the summary of it. Like I said, we're going to take a look at the lawsuit here, but in a little bit and kind of look at it in detail. But it seems like the Big Boy restaurant that was outside of Michigan, one of their stores, they maybe was going back and forth with the landlord in terms of the lease, and they didn't renew the lease. And it seems like the Big Boy in Michigan tried to slide in and open up a restaurant, maybe at that location or at least at that territory, which at that point breaches the agreement. And now here we are in court for essentially trademark infringement. So that's where we are now. Hence the thing, we had a deal, because at least initially both of the Big Boy companies had a deal to, hey, you're going to stay out of my backyard with Big Boy, and I'm going to stay out of your backyard with Big Boy. We both going to have trademark rights to it. But it seems like, kind of based on some situation with this whole kind of lease and landlord situation with the building, with one of the buildings, the Big Boy in Michigan tried to slide in and pretty much kind of open up a restaurant in that backyard, which I think is some BS. But let's go through it. And again, I'd love to hear your guys' thoughts on this one. So this is the lawsuit for the week. Let's see here. Here we go right here. Here we go right here. Bada boom, bada bang. And actually, I'm going to kind of blow it up a little bit more. Here we go. So FBBIP LLC is essentially the company that's outside of Michigan. That's what I was saying. I'm going to say the Michigan Big Boy restaurant or Big Boy owner, and then I'm going to say the outside Michigan Big Boy owner. So FBBIP is the owner of the Big Boy trademarks, or the company that owns the Big Boy trademarks that's out of the state of Michigan. And then a Big Boy restaurant group, which I think in this lawsuit is the acronym BBRG. They are the Big Boy restaurant owner, or the trademark owner here in Michigan. So let's look at the introduction here. In 2001, Frisch Restaurants and defendant's predecessor in interest negotiated an arrangement under which they each obtained the exclusive, perpetual, and irrevocable rights to operate restaurants under the name Big Boy and other related trademarks in distinct parts of the country. Hence, what I was talking about as far as, hey, defendants, which again is the Big Boy in Michigan, but it seems like their predecessor and the outside of Big Boy, the company who owns the trademark outside of Michigan, they both agreed that, hey, we're going to both own trademark rights to the term Big Boy. You're going to stay out of my backyard, and I'm going to stay out of yours. The parties represented and agreed that their use will not overlap, and the USPTO registered the parties' concurrent use based in part on their agreement to operate in separate territories. So again, going back to that whole concurrent use, you can have an agreement with the USPTO to say, hey, I agree that we both can kind of use this mark. Now, let me bring it back on myself really quickly, because the company who had the trademark originally, they don't have to agree to it. And to the extent that they don't agree to it, then the USPTO is going to reject the company who tried to file for the trademark on that word later. So just because it is a concurrent use, that doesn't mean that the person who, the person who originally had the mark had to agree to it. And that's one of the things that, as you are kind of maybe finding yourself in this situation going forward, hey, maybe you don't want to agree on somebody else hitting you up and saying, hey, you got the trademark term. It seemed like the USPTO rejected my application because of your application. Because of your trademark. Is it cool if I use and I stay out of your backyard and vice versa? You can say no to that, and then that person is SOL at that point. But for whatever reason, this Frisch, which is the company that's outside of Michigan, they maybe agreed to it, and the USPTO like, okay, if y'all both agree to it, why should I get in the middle? And that's essentially why you file that agreement, and both of y'all get to use it. So let's go here. Since then, the parties have coexisted in their respective territories without issue. Frisch authorized franchisees or corporate affiliates having exclusive own and operate a restaurant in Frisch territory under Frisch's registered trademarks, including the Big Boy name. And that term Frisch is what's the name? And BBRG, which again is the Michigan, and its predecessors and affiliates have similarly operated restaurants in their territory under their registered trademarks, including the name Big Boy. So Frisch recently became embroiled in a lease renegotiation dispute with a single landlord that owns real estate on which multiple corporate-owned Big Boy restaurants operated. Rather than renegotiate the lease term, the landlord initiated eviction proceedings and forced Frisch to begin closing those restaurants on October 24th. So pretty much, again, bringing it back on myself, the outside of Michigan Big Boy, their landlord said, we not dealing with you no more. The lease ended, you got to get out. And they essentially forced them to get out. So essentially, that's where we're standing right now. This is the company that's outside of Michigan. So let's go here. To save Frisch's system from total collapse, New Frisch's and its affiliates acquired certain assets from Frisch's and its affiliates for fair market value in November 2024, so last year, including the trademarks that issue in the dispute, the franchise agreements governing the operation of franchise restaurants, and the assets of certain remaining restaurants. New Frisch's and its affiliates intend to continue supporting existing restaurants, including saving hundreds of jobs, funding the employees' pension plan, and providing healthcare benefits, and rebuild the number of restaurants within Frisch's territory. Unfortunately, BBRG has opportunistically and unlawfully seized on Frisch's hard times as a pretext to ignore New Frisch's federally protected trademark rights to exclusively operate restaurants within Frisch's territory under the Big Boy name. So I'm gonna, as opposed to saying Frisch, I'm gonna say the outside. I continue to say Frisch, but again, essentially, and again, you guys have to kind of keep in mind that this lawsuit is actually being drafted by Frisch attorneys. So again, obviously, it's going to be, it's going to make them look good and sound good. So BBRG seeks to reopen the restaurants recently closed by Frisch in what is now New Frisch's exclusive territory under BBRG's confusingly similar Big Boy name. Because the USPTO base its approval of the parties' concurrent use registration of their agreement not to use their trademark within each other's territory, BBRG's unlawful conduct, if not stopped, will result in cancellation of New Frisch's trademark rights and complete demise of New Frisch's system. BBRG intends to begin reopening the restaurants under the name Big Boy in 2025, which again is next month. So again, just kind of recapping here. Big Boy, the Michigan, the Big Boy company that's outside of Michigan, it seems like they had this landlord who pretty much had a lot of different properties that they were leasing to the company outside of Michigan. And seems like for whatever reason, which is kind of weird, the landlord is like, hey, we're not dealing with y'all no more. We kicking y'all out. We evicting y'all. And typically, so at that point, it seems like Frisch had somebody else essentially buy the rights to like the restaurants and the trademarks and all that. And typically, when you do an agreement, so when Frisch did the agreement with BBRG or the Michigan Big Boy Company, you will have this clause that says, hey, these this agreement is going to essentially transfer to anybody who buys our rights from them. So that's typically how these agreements are. So again, Frisch is like, hey, well, we selling our essentially restaurants and trademarks to this new company, which the new company now or the BBRG or the Michigan company is still bound by our agreement. So that's that we cool with that. But for whatever reason, the Michigan Big Boy Company was like, they saw an opportunity, and it seems like they are, again, we'll see if they open up. March 2025 is next month. It really is in a couple of weeks. So we'll see if the Michigan Big Boy actually opens up in Frisch's territory. So let's go to 6 here. Contemporaneously with filing the lawsuit, New Frisch's has filed an arbitration demand with the AAA under the mandatory arbitration provision contained in the parties' agreement governing the use of their trademark. It brings this action under an express carve-out to that arbitration provision and seeks an emergency TRO and preliminary injunction prohibiting defendants and attorneys and all other persons who are active counsel or participation with any of them from infringing on New. Essentially, they're trying to say, hey, we're trying to go through arbitration based on the agreement between us, and we want the court to pretty much issue a TRO, a temporary restraining order, so that the Michigan Big Boy restaurant cannot open up in our territory. So it seems like New Frisch's is a Delaware company, BBRG is a Michigan company. I'm not going to go through the jurisdiction and venue, but let's go to the background. So defendant or the Michigan Big Boy Company irrevocably transfer ownership of the Big Boy marks within Frisch's territory to Frisch. Big Boy brand and rest. Man, I didn't realize that Big Boy was around since 1936. they've been around for 100 years. So to their credit, almost 100 years. To their credit, I'm like, man, to be open still 100 years, almost 100 years later is admirable. And obviously they got to do some kind of maybe rebranding or something, because at least when I go to these big boy restaurants, it's a few people in there. It's not a whole lot of action being seen by these big boy restaurants. Let me know if maybe in your city or your state, the big boy restaurants slap. But here in Michigan, the ones I go to, at least, them joints be empty. But again, that Slim Jim is still solid in my books. So here we go. Item 11. Big boy branded restaurants began in 1936 when the founder opened a 10-seat diner in Glendale, California, where he pioneered the double-decker hamburger that he called the Big Boy. I'm assuming that the double-decker hamburger is just 2 patties. That's crazy to think that he pioneered that, but okay. In 1952, members of the Ilias family became the first Big Boy franchises when they obtained from the founder the right to develop and operate franchise Big Boy restaurants in the state of Michigan. So it seems like original Big Boy opened up in Cali in 1936, and the Michigan family, with almost 20 years later, essentially started franchising the restaurants. The Marriott Corporation acquired the Big Boy franchise system from the founder in 1972. So now we have the system is owned by the Marriott Corporation. It's no longer owned by, I guess, the founder. I'm sorry. That's interesting why they didn't give the founder name. Whatever. So 15 years later, Marriott sold the franchise to the system in Elliott. So it seems like now the Michigan company owns everything at that point. So Marriott sold it to the Michigan company 15 years later. The Elliott's family, through their entity, owned and operated the Big Boy franchise system until filing for bankruptcy in 2000. So it seems like in 2000 they filed for bankruptcy. In December of 2000, Liggett Restaurant Enterprises, LLC, and affiliates purchased the Big Boy franchise system and the rights to certain federally registered names from the Michigan family, from the Ilias family, which purchased the bankruptcy court approved. Which again, I was just telling you all this early on. And I mean, I skim these lawsuits, so I don't kind of read them in detail. I skim them just to make sure I kind of understand what's going on generally. Then I talk about it. But this exactly is what I was going through, what I was talking about with the whole Nikola situation. Look at these bankruptcy proceedings is an opportunity to get IP for the low. And it seems like the Elliott's family in 2000 had some issues, filed for bankruptcy, and the Liggett Restaurants Enterprises bought these trademarks, quote unquote, or in other words, IP from the Elliott's family. That just made me happy for whatever reason. The fact that all came full circle from what I was talking about earlier with Nikola. At the time of the purchase of the Big Boy system by Liggett, Frisch's owned and exclusive franchise rights. Hold on. Frisch's at the time of purchase by the Big Boy system by Liggett. Okay, so Liggett essentially owns the Michigan franchises. And it seems like Frisch's owned exclusive franchise rights for the Big Boy brand in Indiana, Kentucky, Ohio, and Tennessee. So these other countries, which is deemed as the Frisch's territory. So you have the Michigan Big Boy, then you have Frisch's, which is kind of leading up to what I was talking about at the beginning in terms of the summary. It seems like Frisch's was already owning the franchise rights to the Big Boy in other territories that wasn't in Michigan. So Frisch's and Liggett agreed to permanently separate their operations going forward, with Liggett, among other things, transfer ownership by the Big Boy marks to Frisch's within the Frisch's territory. Now, this is interesting because it's kind of leaving out some information, in my opinion. But ultimately, what they're saying is, hey, the non-Michigan Big Boy restaurant, which is owned by Frisch's, and the Liggett, which is, again, the Michigan Big Boy restaurant, they pretty much agreed to permanently separate their operations going forward. At the time of the purchase of the Big Boy system by Liggett. See, they say Frisch's, at the time that Liggett got it for the low in bankruptcy court, Frisch's already owned the exclusive rights for the Big Boy brand. But again, it doesn't tell you how did they get the rights to the Big Boy brand. It just seemed like they're saying that they were already operating in different states and counties Okay, to effectuate that separation, Frisch's and Liggett entered into 3 agreements of even date. The transfer agreement dated January 12th, the limited concurrent use agreement, which I was talking about. You usually file that with the USPTO saying, hey, look, I'm cool. We both are going to be using this mark in our respective territories. The transfer agreement date and intellectual property use and non-compete agreement. Okay, which obviously makes sense as a non-compete. IP use seems like that's typically within the concurrent use agreement, but okay, it seemed like it was 3 separate agreements. First, the transfer agreement provides that at the closing, Liggett shall convey to Frisch complete, absolute, perpetual, and irrevocable ownership of the big boy marks within Frisch's territory. And Liggett shall retain complete, absolute, perpetual, and irrevocable ownership of the big boy marks outside of Frisch's territory. Liggett shall convey to Frisch. So it seems like Liggett or the Michigan company, when they say Liggett shall convey to Frisch, that means that Liggett had ownership in the mark and Frisch didn't have ownership. So that's why Liggett had to convey Frisch ownership and essentially ownership in a mark. But again, Liggett didn't have to do that. Liggett could have told Frisch to kiss off and F off, and I mean, obviously, probably would have been a big issue in court. And no, Frisch would have been able to continue to use the mark, I'm assuming, in their territories because they were already doing it, but they probably wouldn't have been able to open up in other territories or new territories. But, it seems like for whatever reason, Liggett was like, okay, I agree to it just to maybe stay out of court and having to pay money. So it seems like that's where we're at. Second, the limited concurrent use agreement consists of a single paragraph requiring Liggett to assist and cooperate with Frisch's effort to obtain concurrent use registration of big boy marks within Frisch's territory. Okay. Third, under the IP use agreement, the parties covenanted and warranted that they would use the big boy marks in a manner which would not materially detract from the big boy reputation, specifically in connection with the operation of the restaurants the parties agreed to. So essentially, they're going to essentially use it in a similar manner so we can keep the value of the company up or the value of the name up. So again, for example, not permit gambling or other adult themes or activities or adult atmosphere. So you can't, one of the big boy owners can't all of a sudden have girls walking around there like they Twin Peaks or Hooters. So that'd be kind of, at least in their opinion, based on this agreement, disparaging to the big boy name. Have to be displayed, maintain, and operate restaurants in good condition and repair. So you can't be running slum restaurants. Yeah, that's pretty much it. The IP use agreement contains no requirement that either party operate a minimum number of restaurants or maintain. Okay, that makes sense. On the contrary, for purposes of allocating costs of defending against third-party attacks on the big boy mark, the IP use agreement expressly acknowledges that the number of restaurants operated by the parties may increase or decrease. Okay. The IP use agreement contains a mandatory arbitration provision. That's the whole AAA thing that requires the parties to submit all disputes arising under or relating to the interpretation of this agreement, including without limitation, all disputes concerning the use of the big boy marks to final and binding arbitration. Again, a lot of times you're going to do arbitration because filing a lawsuit is going to be expensive, and arbitration is going to be a lot less expensive. So typically, these type of agreements have an arbitration clause to say, hey, we're going to let an independent arbitrator rule on the interpretation of a particular issue as opposed to going to court, which is going to cost us a lot of money and maybe cost us a restaurant. So that's kind of pretty standard. The arbitration provision permits courts to grant interim equitable relief in the aid of arbitration. Okay. Before invoking arbitration for a breach of contract claim, the IP use agreement requires the company party to notify the breach party of an alleged default in writing. Okay. Yeah, whatever. The IP use agreement contains no provision allowing. Okay, let's get to the important stuff. The USPTO registered Frisch's exclusive right to use the big boy marks within Frisch's territory. The current use registrations are rare. Yeah, I would say that they're rare, but it is a possibility. Because again, the reason that they're rare is why would you agree to it? If I got the trademark to a term and you can't get your trademark to a term because I have mine first, why would I agree to say, okay, I'm gonna let you get to have a trademark on this term as well? Why? That's the whole point of you getting a trademark is to prevent others from using a mark. But a concurrent use is pretty much saying, hey, I'm sharing my trademark with you. So, I mean, I agree that it's rare. That's why I was like, okay, Liggett, the Michigan Big Boy restaurant, you already had the trademark. Why would you agree to give it to Frisch? That made no sense, or it makes no sense. Let's get back to it here, though. On April 4th, 2002, Frisch submitted a concurrent use application for registration of the standard character Big Boy service mark in Frisch's territory. On December of 2003, USPTO registered it. Again, the USPTO doesn't care. They're gonna file the agreement and kind of register the marks. On February 15, 2006, the USPTO canceled that registration, explained that a clerical error had resulted in an approval without required concurrent use proceedings before the TTAB. On November of 2006, the USPTO instituted concurrent use proceedings. On November 7, 2007, on November of 2007, Frisch's and Liggett successor, BBRG, to the 2001 agreement, Big Boy Restaurants International, entered into an agreement reading regarding use of the trademark, okay? The 2007 agreement reaffirmed the 2001 agreements and again provided that each party could only advertise or use the Big Boy marks in their respective territory and for their respective goods and services. Frisch filed a motion for the TTAB to accept the concurrent use and agreements to dismiss the concurrent use proceedings. On August of 2009, the TTAB, which is essentially the Trademark Trial and Appeal Board, Trademark Trial and Appeal Board, here we go. Critical to the TTA, it's the Trademark Trial and Appeal Board decision was the party's representation that neither party will use, okay, whatever. On August 18th of 2009, the commissioner of the USPTO entered an order restricting BBR right R's registration of the Big Boy marks to the United States except for the Frisch's territory. So again, they just accepted the concurrent use agreement. The order further held that Frisch's was entitled to concurrent use registration. They pretty much just gave rights to Frisch. Frisch has continuously, exclusively, and extensively used the Frisch's Big Boy marks in the territory. For decades before and since Frisch obtained registration of the Frisch's Big Boy marks, Frisch's and its authorized franchisees and licensees have continued. They pretty much said that they used it. They're registered on the principal registrar's office with the registrar with the USPTO. They pretty much are using it. It's pretty much saying that they're using it. So this is the good stuff. This is where we get off into the good stuff. Defendants intends to imminently open restaurants in Frisch's territory under the Big Boy marks. In 2016, a private investigator, look at man, when you have to get a PI involved, a private investigator, you're already fucked. In 2016, a private investigator acquired all shares of Frisch's. As a result of that transaction, a private investor, I should say, my apologies. A private investor, okay, Frisch's LLC and acquire, the IP, including essentially the Big Boy marks in connection with the 2016 transaction. National Retail Properties, so LP, became the owner of the real estate and lessor for many corporate-owned Frisch's Big Boy restaurants, okay? Beginning in 2020, the global, we had obviously, hey, look, I don't know about that, whether or not that the pandemic had anything to do with the financial performance. I didn't really see anybody yet Big Boy before COVID, but that's just me here in Michigan. In the aftermath of the pandemic, so I would imagine that, hey, look, this is making sense now. I would imagine that they didn't renew the lease because they probably stopped paying them. So they're like, man, if y'all hadn't paid me, so of course I'm not going to renew the lease. I want to get y'all out of there. I don't want anything to do with that. Do with y'all. And they probably did that for all their restaurants. So now this is making sense. That's why they evicted them. Oh, I got you. See, look it. That's what you got to read in between the lines. This is Frisch's attorney, so they're going to make them look good. But you got to read in between the lines of what's going on. Okay, so in the aftermath of the pandemic, the commercial real estate market has experienced a significant recalibration with land. And again, it seems like Frisch's didn't want to pay what they was paying before. Frisch's had been embroiled in a renegotiated dispute with the Triple N over the inflated and unfair lease terms. Oh, it was all of a sudden unfair because, post-pandemic. Well, I guess a lot of people were saying that. Rather than renegotiate, Triple N recently commenced eviction procedure. Yeah, get the fuck out. To save the system from total collapse, New Frisch's and its affiliates acquired certain assets from FRI entities for fair market value, including the trademarks. Okay. New Frisch's now owns the Big Boy marks and licenses they're used to authorize franchisees and licenses under the, okay, yeah. Man, get to win the Michigan Big Boy restaurant time to open up. On November 8th, 2024, New Frisch's notified BBRI that it had bought Frisch's interest. New Frisch's. Okay, so they're pretty much saying, hey, we essentially, own Frisch's interest in that agreement that we filed with y'all early 2000s. On November 11, 2024, BBRG responded to New Frisch's notice. BBRG accused Frisch's of breaching the contract, the concurrent use agreements, claiming that the closure of the restaurants in the Frisch's territory would somehow damage BBRG's big boy marks and reputation in separate territories. And see, let me see. They're not telling it all. Because again, that's a standard contract term that, hey, if I sell my company to somebody else, you still, that agreement is still active between the Michigan Big Boy restaurant and who I sold it to. It seems like who Frisch sold the interest and all that to, seems like they maybe wanted to do something else that the Michigan Big Boy restaurants wasn't too hot on. That's just kind of, like I said, me reading in between the lines so far. Seems like that's what's going on, but let's take a look at it. On November 27, 2024, New Frisch's refuted BBRG's or Michigan Big Boy allegations through a written letter which explained, among other things, that BBRG or its predecessors had similarly closed numerous restaurants and engaged in conduct that reflects poorly on their reputation, yet Frisch's had never sought to terminate the party's absolute, perpetual, and irrevocable agreement. Hold on. Closed numerous restaurants and engaged in conduct that reflects. Okay. Indeed, the number of BBRG Big Boy restaurants decreased from 159 to 53. And during the same time period, BBRG has ceased operating entirely in at least 5 states. I didn't know the Michigan Big Boy was outside of Michigan. By late December 2024, Frisch's had closed all restaurants previously operated under the lease. By late, Frisch had closed all restaurants previously operated. On December 2020, BBRG informed New Frisch's that BBRG interpreted the concurrent use agreement to provide New Frisch's with the conditional right to use the Frisch's Big Boy mark, even though, among other things, states absolutely. Upon information to believe, the reason that the Triple N had refused to renegotiate the lease and instead initiated because y'all weren't paying them. Oh, so it seemed like Frisch is saying, hey, they didn't want to negotiate and evicted us because the Michigan Big Boys said that they would essentially come into the territory and lease up these restaurants. Interesting. And that was a violation of the concurrent use agreements in the Lanham Act is what Frisch is saying. According to online employment advertisement, BBRG initially intended to rebrand the closed restaurants as Dolly's Burgers and Shakes. I said it earlier that Big B needed a rebrand. Maybe that's what probably would have worked out. The character Dolly's has existed in the Big Boy universe. Okay, so it seems like it's it's almost like kind of you have this universe Big Boy and you have these different characters, and now they're kind of forming a restaurant on one of the characters. Again, I'm all for that. BBRG has a separate trademark registration for the Dolly's chicken sandwich, which was registered in 2021. Okay, so they're rebranding. Accordingly, New Frisch has refrained from seeking relief from the court based on his understanding that BBRG will reopen the closed restaurants under a different name. But last week, New Frisch has learned that BBRG would be reopening the closed restaurants under the Big Boy name. New Frisch. So it seems like they're saying that Michigan Big Boy pulled a quick one on them. Okie doke. Online job postings now no longer seek employees for Dolly's Burgers, but for Big Boy. And it's a dirty game, man. An investigator hired by New Frisch recently applied for a BBRG job opening for one of the restaurants during the pre-screening interview with BBRG's human resource manager, Tom. Tom informed the investigator that BBRG would be reopening all the closed restaurants under the Big Boy name. Tom further advised that BBRG intended to implement management teams by mid-February, hire hourly. Okay, so it seems like they're essentially going back on their word, and the Michigan Big Boy company who's going into Frisch's territory is no longer opening under what Dolly's Burger and Shakes, but under Big Boy. Contemporaneously with the filing of the lawsuit, New Frisch's has initiated arbitration demand. Okay, so hey man, that was actually a pretty interesting lawsuit if I had to guess. I'm not sure what's going to happen. It seemed like Frisch was maybe trying to kind of do some interesting, I don't want to say some funny business, but again, to close all the restaurants because you couldn't renegotiate the lease, yet you're giving ownership and all that in to another company which is kind of deemed new frisk. And it seems like the Michigan big boy, they wasn't having that. They came in. And it seemed like they both was kind of, the Michigan big boy restaurant was doing some kind of shady stuff as well, saying that they're going to open under the Dolly's or Burgers and Shakes, but then switching that to big boy. So it seems like both parties are kind of maybe doing some shady stuff, if you ask me. And I would imagine that they're going to get down to it in arbitration. So, yeah, hopefully you guys got something out of this. This was wildly entertaining. They're typically not that entertaining. And I love the fact that what I was talking about earlier with the Nikola, seems like when big boy restaurants faced bankruptcy in 2001, the Liggett ended up kind of buying the trademarks. So it is value in trademarks, particularly when companies file for bankruptcy. So hopefully that's what you got out of this whole this live, or not live, but this show today is bankruptcy equals opportunity. Hopefully you guys got something out of this. Please hit the like button for the YouTube algorithm, as well as hit the subscribe button to be a part of the IP community. Go check out the video of me, filing a copyright in real time. And again, you have to be a member, but please go check out that video. And I will see you guys next Sunday, hopefully live in this case. Now we'll get to it. All right, you guys take care.